February 2nd, $12,000 sanction. February 5th, referral to the Office of Professional Conduct. In the past 4 days, 5 different courts had to step in because lawyers filed briefs with fake cases. Look, we're past the point of asking, is the technology ready? The only question left is your license safe? In just a minute, I'm going to explain exactly why AI will lie and how to keep that lie out of your filings. My name is Patrick Nolan. I run an AI-powered law firm. And if you think you can copy and paste from ChatGPT into a motion without consequences, I have a $12,000 receipt that says you're wrong. Let's take a look at the damage report. This week in AI will lie. Lexos Media v. Overstock. This is a patent case. 5 attorneys on the signature block. Co-counsel used ChatGPT to draft a Dalbert response. His actual prompt, and I'm not making this up, was taking the role of a judge, write an order that denies the motion to strike with case law support. He didn't verify a single citation. 11 fabricated or misrepresented authorities across 2 briefs. Nobody on his team checked. The court did. The result? $5,000 fine for the drafter. Pro hac vice status revoked. Self-report to the state bar. $3,000 fine each for the partners who signed on without reading. $1,000 for local counsel who read it but didn't cite check. $12,000 total. That's not the cost of AI. That is the cost of laziness. Arkansas DHS v. Ward, the Arkansas Supreme Court case. Attorney ad litem. 25 years of practice. Used Microsoft Copilot. Microsoft can't make Windows worth crap. Used Microsoft Copilot. Prompted it, can you provide case law support to this argument with citations from Arkansas dependency neglect law? Didn't verify, filed it with the state Supreme Court. Written reprimand. Self-reported to the Office of Professional Conduct. The court warned that under different facts, the consequences could be suspension or loss of privilege and practice. That is how careers end. Quietly, in a footnote. The rest of the week, Mills in Missouri, pro se plaintiff, got his case dismissed with prejudice after citing fake cases in his response to a show cause order about citing fake cases. Button in Florida, pro se litigants fabricated citations over 50 times, got warned by a magistrate, and then did it again in their objections. The judge found bad faith. Urenke in Pennsylvania, a detainee's habeas petition cited middle district cases that don't exist. One of them actually pointed to a family court decision from Quebec in French. Different courts, different tools, the same failure. This wasn't the software. This was the workflow. And here's the technical reality that you need to understand. AI will lie. And if you don't understand why, then you're going to risk being on one of these orders. Large language models are not search engines. They're not databases. They are prediction machines. They predict what the next word should be based on patterns in their training data. When you ask an LLM to give me a case that supports this argument, you've given it a job. Be helpful and produce a citation. You know what you haven't told it? Don't make one up. It has no concept of real versus fake. It doesn't check Westlaw. It generates text that looks like a case citation because that's what fits the pattern of your request. And AI will lie with absolute confidence. It won't hedge. It won't say, I'm not sure this exists. It will hand you a perfectly formatted citation with a quotation that sounds exactly like something the Federal Circuit would say, because the model learned what Federal Circuit opinions sound like. And that's why AI will lie confidently. Perfect blue book format. Convincing quotations, language that sounds like the Federal Circuit. If you treat that like Google, you are committing malpractice. Period. So does this mean you ban AI? No, of course not. That's like banning email because someone sent a phishing scam. but you have to change your workflow. Here's how I use AI without ending up on a sanctions order. Rule 1, never use generative AI on a final draft of any legal work. AI is for ideation, first drafts, outlining, summarizing, issue spotting. It is never the final author. The second you paste an AI-generated citation into a brief without independently verifying it, you have violated Rule 11. Full stop, no questions. Rule number 2, verify every citation, every single one. Come on, y'all should have been doing this anyway. You verify your associate's work. You verify your paralegal's work. Why would you trust a chatbot more than your own staff? Before AI existed, you're supposed to shepherdize your cases. Read the actual holding. This is not a new obligation. AI just made the consequences of skipping it catastrophic and faster. If you aren't verifying every single citation against Westlaw, Lexos, a fast case, you are negligent. My 30-second rule, hold the case, read the passage, confirm the quote. If it doesn't exist in Westlaw or Nexus, it doesn't exist. 30 seconds per citation versus $5,000 fine and referral to the state bar, that is a no-brainer. Okay, rule number 3, use AI where the return on investment is high and the risk to your license is 0. Accounting. I use AI to process receipts and accounts payable. Okay, my office manager saves 10 to 20 hours every month because of this. It saves me $300 to $600 a month and a bonus every tax time. It ain't sexy, but this is real return on investment that doesn't endanger my license. Document review and extraction. I drop a 40-page discovery response into our in-house LLM. It's a 27B model with instructions to pull all the names, contact information, and context for why that person is in my discovery doc. Then I have it write an email to my paralegal with the information to start making contact with the witnesses. Okay, we drop statements in and we look for inconsistencies across statements. This saves us 1 to 10 hours per case, $250 to $2,000 per case. That's an amazing return on investment. Okay, the workflow automation and triage. We use AI to classify incoming emails, route intake form submissions, flag calendar conflicts. Okay, sort documents into the right client folder. This is pattern matching on structured data. It's not generative output. Nobody's getting sanctioned because an N8N workflow incorrectly tags an email as a new client inquiry instead of existing client follow-up. All three of these share the same characteristic. AI is processing existing information, not creating new authority. And that's the line. AI enhances cognition. It doesn't replace it. It doesn't think for you, it thinks with you. When AI works well, it widens the search space and it compresses time. What it does not do is judgment. That's what lawyers are for. Really, look, that's all we bring to the table, man. My paralegals do office work better than I can. My office manager handles the books. I don't know how to use QuickBooks, but I do know how to lead a team, and AI is part of that team. My job is judgment. The lawyers in these cases outsource judgment, not labor. AI is a power tool for the mind. Power tools amplify skills and mistakes. A nail gun doesn't replace a carpenter. It lets a carpenter work faster or lose a finger faster. Lawyers are getting sanctioned, didn't use AI. They abrogated their cognition. They failed to supervise their AI employee, and they paid for it. And the judge in Kansas said it perfectly. The violation isn't using AI. The violation is failing to verify what it gives you. Use the tech. The return on investment is massive. But understand what it is. It's a tool, not a lawyer. And if you let it practice law for you, the bar is going to make sure you don't practice at all. I'm Patrick Nolan. Watch your citations.